Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 24 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between November 24th, 2020 and December 1st, 2020. In the case of Zitney versus Wyeth, Zitney is suing a pharmaceutical manufacturer for failure to adequately warn the prescribing physician of the potential side effects. In this case, the pharmaceutical company included warnings in the packaging of the medication. Zitney is arguing that those warnings were inadequate because they failed to provide a specific Dear Healthcare Provider letter to the prescribing physician. At the trial court, the judge granted the pharmaceutical company's motion for summary judgment, stating that Pennsylvania law does not impose a duty on a drug company to provide a Dear Healthcare Provider warning, and that including the warnings with the medication packaging is sufficient to comply with their duty to warn. The Superior Court agreed with the trial court finding that the pharmaceutical company had satisfied their legal duty to warn, and therefore the granting of the motion for summary judgment was proper. The case of Long v. McFarland is a trespass and nuisance action brought by Long against the McFarland property as a result of overgrown trees that are causing damage to the Long property. Long first noticed the overgrowth and damage beginning in 2009, but did not bring this action until 2019. The estate of McFarland filed a motion for summary judgment claiming that the case must be dismissed as the statute of limitations had run. The trial court granted the motion for summary judgment on the statute of limitations grounds, and this appeal followed. The tort of trespass is any physical entry upon the surface of the land and may occur by any number of means, such as walking on, flooding, or throwing objects. A nuisance is an unreasonable, unwarrantable, or unlawful use by a person of his own property producing such material annoyance, inconvenience, discomfort, or hurt that the law will presume a consequent damage. Actions for trespass and nuisance are both subject to a 2-year statute of limitations. However, when the statute begins to run depends on whether the wrong is permanent or continuing. A permanent trespass or nuisance is one that affects a permanent change in the condition of the land, and the statute would begin to run at the time of the original trespass. In a continuing nuisance or trespass, it is impossible to know how many incidents of trespass will occur in the future or the severity of the damage that may be caused, such that the full amount of damages cannot be calculated in a single cause of action. For that reason, a party aggrieved by a continuing trespass or nuisance can maintain a succession of actions based on continuing infractions or aggravation of the original offense. Here, the court found that the trespass and nuisance were continuing in nature, as the continued growth of the trees could cause unknown future damage, and therefore the statute of limitations had not run. The trial court erred in granting the motion for summary judgment, and the case is remanded to the trial court to be addressed on the merits. The final case of the week is Donnell v. Donnell. It addresses a factual specific inquiry into the obligations of a putative but not biological parent in a child support case. In this case, mother was pregnant with child at the time she met the putative parent. Putative parent was listed on the child's birth certificate, and his name appeared on a certificate of paternity. Several years later, they divorced. Mother did not seek child support. Later, mother suffered a back injury and was unable to work. She wanted to obtain public financial assistance. In order to be eligible, mother had to seek child support. During the course of the litigation, credible evidence was presented that putative parent did not in fact sign the acknowledgement of paternity, and without such documentation, putative parent bears no financial responsibility. Thanks for joining us again this week. As always, the full text of each case can be found in the case notes. I hope everyone has a great week, and for whoever needs reminding, get a jump on your holiday shopping.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.